so much for your words of wisdom. I'm sure we all are motivated. So now we are going to start with our final round. I would like both the parties to please kindly come and take their seats. Whereas I would like today's judges are Dr. K.K. Mittal, Dr. Shalini Tyagi, and Mr. Vikram Pratap Singh. So I would like you judges to please come and take your seats. All the very best, everyone. I hope you're going to win. I hope the best wins.
They both contracted for the construction of multi-purpose building at rupees 9 lakh. At several times, Tarun Bajaj has promised Mr. and Mrs. Padma and Baba to pay them the amount mentioned in the contract. After the completion of the building, he assured Mr. and Mrs. Padma that he will pay the full amount after his deed pending at that time. But after not paying anything from Tarun, Padma and Baba and on his 18th birthday altered the contract and promised to pay monthly EMI of rupees 20,000 is the date on which there is a completion of the amount of rupees 9 lakh. After 15 days of not getting any installment, Mr. and Mrs. Varma and Varma has to approach the Civil Court of Kuntal, after which they appealed in the High Court of Kuntal in the Indigo. The first issue that is raised is whether there is a valid contract between Mr. and Mrs. Varma and Varma and Mr. Tavambada. Yes, there is a valid contract between Mr. and Mrs. Varma and Varma and Mr. Tavambada. Contract should be in free consent, but here it is not free consent. Misrepresentation is defined in under Section 18 of the Indian Contract Act 1872, which says misrepresentation is a form of a statement made preceding to the contract being completed. According to Section 19, when consent to an agreement is caused by coercion, fraud, or misrepresentation, the agreement is a contract voidable at the option of the party whose consent was so caused. And in the above situation, a party whose consent was done by misrepresentation is Mrs. and Mr. and Mrs. Varma and Varma, not Tavambada. So the contract can be void on the condition that Mr. and Mrs. Varma will file a petition. As per Indian Contract Act 1872, any person, a domicile of India, who is not yet 18 years old is called a minor. A minor is a person who does not reach the age of 18, and everyone who gets into a contract has to attain 18 years of age. According to Indian Contract Act, a child's contract is void, meaning it has no legal standing. The minor is not allowed to be a partner in joint venture company. However, an unauthorized person may agree to all parties involved may be allowed to benefit from the partnership. With some exceptions, a contract made by a minor is voidable. The minor, in other words, may avoid the legal liability under the contract. Upon reaching the age of majority, a minor may affirm or ratify the contract and therefore make it contractually binding on him. That was same done by Mr. Tavambada on his 18th birthday, where he not only accepted the money, that is rupees 9 lakh for the contract, he also altered the contract and promised to pay the amount in the monthly installment of rupees 20,000 if the repayment of the amount of rupees 9 lakh was done. But in the above situation, the major, when he paid up to 20,000 the EMI, up to 15 days later by presenting the false statement about the construction by the Mr. and Mrs. Varma and Varma and refused to pay the rupees 9 lakh rupees. There is a case of Tyagi versus B, in which the court defined fraudulent misrepresentation as a statement known to be a false or a statement made recklessly or carelessly as to the truth of the statement. That was same done by Mr. Tavambada when he represented his age to be of 18 years. The second issue is here whether the judgment passed in the Mumbai BP versus Dharmada's Ghosh needs reconsideration. There is a need of the reconsideration in judgment passed in the Mumbai BP versus Dharmada's Ghosh because the applicant was not aware of the age of the respondent, as there was a damage according to Section 73 of the Indian Contract Act deals with direct damages. It means damages which naturally arose in the usual course of things from such breach, or which the parties knew to be likely to result from the breach of it. Special damages do not mean serious damage in the sense of irreparable loss, but damage affecting the plaintiff individual or beyond what is suffered by him in common with orders and contract law. Unlike normal losses, which are losses which every plaintiff will suffer, such as general damage, consequential losses, are anything above the normal losses, such as profit loss or expenses incurred through the breach and are revocable if they are not removed. Since Mohili was Dharmada's case was a precedent for all minor cases, and there was since no plea of restitution for the plaintiff. The question here arises is that is the mental capacity of a minor to know the nature of the act is same that was in 1895 when this dispute arises between Dharmada and Dharmada's Ghosh, as it is now more than 100 years, and it can be seen that as we are going advanced, the minor's capacity to commit the crime and also to know the nature of the act increases. The trial court in Mohini was court is held that such a mortgage deed or contract that was commenced between the plaintiff and the defendant was void, as if it was executed by a person who was a minor at the time of the execution of the mortgage. Consequently, Babu had not been satisfied by the trial court judgment, filed an appeal in the Calcutta High Court. The Calcutta High Court in Mohini was the case. We affirmed the trial court verdict and dismissed the appeal. In this, the promoter, who later know that he was a minor, the Damodar's coach was a minor, but in case of the third Bajaj, he misrepresented his age, he made a full scenario that he is a major. He continuously contracts with the other producers like sunshine producers, he contracts with directors, he misrepresented his age and he acted as a major.
We not only misrepresent with the Mr. and Mrs. Varman, but also with the sunshine producers and along with the other producers. The third issue is that whether the civil court of Kuntal was correct in rejecting the plea of the restitution. Civil court of Kuntal was not correct in the rejection of the plea of the restitution. Civil court of Kuntal reconsidered the plea of restitution of Mr. and Mrs. Varman as there was a consequential damages on the reputation. On the judgment passed in the civil court of Kuntal, the English common law, however, applied the law of the restitution of the case where the minor misrepresented his age when he entered in a contract with a general principle under the common law. If a minor misrepresents his age and receives any money or benefit from that contract, he must restore to the person whom he received it, provided that it is still identifiable.
There is a case law, Ajulia Prasad and others, versus Chandan Lal and others. Therefore, one of the parties are minor as incapable of contracting, so that their neighbor is and never can be a contract. Section 65 can have no application to such a case as a section. We start on
that we are discussing this problem not only at the time when the Mohini case was decided. We are discussing it.
At the time 2022, there are so many ways by which we can ascertain the age of the minor. There may be the document, whether the worldwide company shall scrutinize the document or not. Whether you refer to anything else or not.
Sir, in this case, where the Tarun Bajaj is a famous personality. Everybody knows him. He is the national. He has also sensational voice of the nation award. He had just given his head, in which he has tends to be a major. He and on everyday course he contracts with the directors of music, different music directors, different filmmakers, different producers, and also the sunshine producers. That made Mr. and Mrs. Bata believe that he is a major. As in his ordinary course, he is not acting as a minor, and he has no reason to believe for the Mr. and Mrs. Bata that he is a minor.
Suppose we are having pretending that I am a major, that will not be treated as a major. Only by that.
There is no procedure. How can you prove that that contract should be executed? Can we cite any few things or few judgments in that paper?
Sir, in today's time, the Indian courts, whether it is the High Courts of various states or whether the Supreme Court, is continuously referring the Damodar's Ghosh case and Mohini case for deciding the minors age and deciding the contracts in which minors are involved. But sir, there is a strict need to reconsider this judgment because the case took place in 1895 and we are in currently 2022. There is a huge gap of the mental ability of the person that was living in 1895 or that who was living in current 2022.
It means you want to challenge the Indian majority act?
Yes, sir.
On what basis?
So like on the mental capacity to understand the nature of any act, whether it is a wrong or right.
In any case, it has to be decided either by an expert or not.
Sir,
In any case,
mental capacity of a person.
Sir, in IPC also, sir, there are many sections, sir, in which the age of a minor.
no, my dear, we cannot equate the criminal side or the civil side at one angle. There is a lot of difference between the two.
There is a lot of difference, but in civil matters, even today the Indian High Court and Supreme Court is referring to that judgment that dated that case that back in 1895. Sir, our question is that there is a strict need to reconsider that case and that judgment is delivered at that time.
So there is no case law. Here, Upper Swami Iyengar and Narayan Swami Iyer and others. So in this, it can be concluded that any agreement or plea in which minor is a party, such agreement shall be declared null and void because such agreement is violation. Any agreement with a minor cannot be enforced against him. In cases where a minor has done dealings without the consent of the parents or the guardians. The true nature of those rights was not discovered by the plaintiff or the Rajpal earlier than the time at which his demand for possession was registered, and that was well within the period of limitation. It was judged that the agreement was discovered to be void, and the discovery in their lordship's view was one with the words and meaning of section 65 of the Contract Act. The plaintiff thereof, though not entitled to recover possession of the wages, is entitled to recover compensation, and in assessing that compensation, their lordship consider it should include the sum of rupees 25,000 found by the courts to have been paid to industry, and also in the circumstances of this case, interest not at the rate or for the period claimed by the plaintiff at 6% from the date of the execution of this suit. In this, there is an execution of the benefits that was made by the minor.
Actually, the minor is minor. Still today, that fact is very well proven, and everywhere it is considered in execution of any agreement or the contract. But you are saying that should be considered as the maker. Then how is it possible in the law, where the law is amended? Anywhere else that the minor can be considered the minor?
Sir, there is a
Whether the intention of the legislature, either in the Contract Act or the Majority Act, is against the Constitution. On that basis, we can prove that, we can say that it is the Constitution.
Sir, there is a one more fact that, sir, on Tarun's 18th birthday, both the parties, on grounds of humanity, decided to alter the contract. Tarun acknowledged the debt taken from Mr. and Mrs. Bhagwan Bhagwan for rendering past services, and further both agreed on the same point that Tarun would pay the debt through easy monthly installments, EMIs of rupees 20,000 per month, if the repayment of the amount of rupees 9 lakh. So when he do this contract, sir, he altered the contract, they both agreed on the same point. Then at that time, he was 18 years of age. That is the age of the majority. So sir, he has a liability. He is liable to recompensate the petitioner.
Again, look, the judgment of the case of the Holy City versus what was happening. It makes no difference if later on he attained the age of the majority, that the time will be seen at the time of the execution, breaking of the contract. As in the, you also said that in the criminal law, the age will be counted at the time of the execution of the offense, not at the time of the punishment. There is a lot of difference between the two.
Yes, sir, it is correct. But in today's time, the court should look on the mental capacity of the that person, not the age. Sir, in the
What are the criteria, what are the points on which basis we can ascertain the mental understanding of that person?
Sir, we can understand the mental capacity. Like Tarun was not only contracting with the Mr. and Mrs. Barber, but along with the music directors and film producers, that will show that he is fully capable of understanding the text.
And it makes no difference that what he is doing in his other life, whether he is a singer, writer, or anything else. But when we talk about the making of the agreement of the contract, then the age, if that has been challenged, and the basis of the age, that naturally the age will be considered. If you are having any additional point you may discuss.
The point is that, sir, on this 18 contract, sir, he not only altered the contract, but he added one new contract, sir. In which, sir, he agreed to pay the monthly EMIs. Sir, if he is a minor, sir, then why on the age of minority, he agreed to pay the money? Why he had not resisted to pay the money or said that I am a minor, when the contract is paid, I am a minor, and there is no legal liability of me. But he has agreed on that point, sir.
And since we also acknowledge the loan or the past services that was rendered by him from the Mr. and Mrs. Father and Mother. And so we can easily escape from the liability that at the time, if you want, that at the time of making contract, I am a minor and I will not pay the amount for the rendering the services.
We must give concrete point on which basis we can say that his understanding was of the majority level and he is taking the benefit not only in this contract, another benefit contract also.
Sir, after his 18 contract also, sir, Tarun later on felt that the work done by Mr. and Mrs. Barber and Barber was not performed as he had specified. He further pointed out that the material used for constructing was substandard and not satisfactory. He estimated that this would have cost him rupees 3 lakh only. He claimed that he had paid money already. Sir, in this part also, sir, he has made a new reason for not giving the money, that the amount is only 3 lakh rupees. That they had used the substandard material, hazardous material. From the age of 16 years to age of 18 years, he has now realized that the material is not substandard. And on his birthday, he has done full-time birthday party. He's living in it. He's doing everything. But now he realized, because he's just escaping the liability from it. He's finding the reasons so that he can escape the liability.
And sir, there is also question on the question also put on the courts that you should also look upon the mental capacity of the person while delivering the judgment or looking on the mental. Not only you should also consider the mental ability of the person to understand the nature of the event, not only the age factor.
What do you want to take for relief from the
court?
Sir, in the light of the issues-based argument advanced and authority cited, it is most humbly put before this Honorable High Court of Kuntal that it may be pleased to hold the contract between Mr. and Mrs. Barber and Barber and Mr. Tarun Bajaj as valid, to uphold the judgment passed in the Mori Giri and Dharmodas Ghosh case, to allow the plea of the execution of appeal, to uphold the judgment passed in the Civil Court of Kuntal, and pass any other order which this honorable court may deem fit in the light of justice, equity, and good conscience, all of which is most humbly and respectfully submitted. Thank you.
Okay, thank you.
Honorable greetings to the bench. With the consent of leadership, may the council address the bench collectively as your lordship. Much obliged. May it please the court, I along with my co-counsel will be representing the respondent side, Mr. Tarun Bajaj. Your lordship, the council will deal with 4 issues, where my counsel will deal with the issue number 1 and issue number 3, and I will be dealing with issue number 2 and issue number 4. If the court is well versed with the facts of the case and has no preliminary queries, may the counsel begin with the submission of the arguments.
Kindly proceed.
Much obliged. I would like to call begin with the arguments.
With the permission of your lordship, shall I continue with my submissions? Your lordship, the Your lordship, the council would like to submit the argument that discussing the issue number 1, which is whether the established appeal is maintainable or not. This will be done on 4 grounds, which is firstly, both the parties have had a reasonable opportunity to present their submission on fair grounds and justified grounds. Secondly, if the present appeal is allowed and entertained herein, then it will bring irreparable loss and grave injustice to the respondent. Thirdly, the appeal stands in contradiction with statute established under section 96 and 98 of Civil Procedure Code and section 41 of Specific Relief Act. Lastly, the appeal, if entertained, will also violate several statutory and fundamental rights of the respondent. It is submitted that the language of section 98 clause 2 of the Civil Procedure Code is imperative and mandatory in terms. The object appears to that on the question of facts in the event of difference of opinion, views expressed by a lower court needs to be given primacy and confirmed, and none of the said condition can be fulfilled in the present case. Therefore, the appellant cannot examine the correctness of the findings of the learned civil court of order. It is submitted that Mohini TV versus Dharmadas Ghosh is a relevant and impartial
No problem, take your time.
Your Lordships, the judgment passed in the Mohini PD versus Dharmadas case does not need to be reconsidered, as the said judgment has been reaffirmed again and again throughout the time. In the matter and in the present matter, I would like to highlight the correlation between the two cases, where in both the cases, the agreement was done, the contract was done with a minor, which became void as an issue in later stage. This can be confirmed from the statement of the facts, where Tushar, being a popular figure of the nation, is known to all in the country, and yet Mrs. Vardha and Vardha, the appellant, agrees to the contention of or misrepresentation of Tushar that he is not a minor. Mr. Counsel, tell us the wrong point only. That what is the wrong point with you to prove your case? That in the present century, we are living in the 22nd century. How the case of the Mohini PP versus Dharmadas Court will apply in this case? Because, Your Lordship, the contract was done between minors, and it is the landmark case of the contract with minors, and the ingredients and essentials discussed under the Mohini PP case is parameter to the present case. And suppose the point of estoppel, which was neglected in the Mohini PP case, is now relevant because in this case the petitioner knew about the knew about the exact age of the respondent because he being a popular figure throughout the nation, and hence this person, the appellants have a malice intention of we can say looting the respondent who was a minor at that stage. With this, I would like to move forward and discuss few statutes in the specific relief act. The present appeal, the injunction is barred under section 41 clause E of the specific relief act, since the learned civil court on merit admitted that the fact of the respondent was minor at the time of conduct, therefore the performance of the same is not specifically exposed. Injunction is also barred by the section 41 subclause I of the specific relief act because he has not approached the honorable court with clean hands and his conduct has been most unfair, dishonest and tainted with illegalities. With this, I would like my co-counsel to present further issues.
Why the benefit of the novation should be given to the B.A.L.B and B.A.L.B company?
This should not be given to the B.A.L.B and B.A.L.B because the section you are referring to, your lordship, specifically states that the parties to contract agrees to the substitute a new contract, and in the present case there is no court contract because the previous contract is void ab initio and it never came into existence. So we cannot claim that it is a novation, rescission and or alteration. Also, I would like to get your attention on another word, which is parties to the contract agrees. In this case, since the respondent was a minor, and hence he cannot be claimed as a party to a contract under the section 11 of Indian Contract Act. Should I proceed?
May the court permit me to present issue number 2?
Yes, proceed.
Much obliged. Whether the contract between the parties is valid or not, it is humbly submitted before the Honorable High Court of Kuntal that the Honorable Civil Court of Kuntal passed a decree declaring the contract void ab initio. That the respondent Mr. Tarun Bajaj is not competent to carry out the terms of the contract for construction of multi-purpose building by the appellant B.A.L.B and B.A.L.B in accordance with the provision of the Indian Contract Act 1872. That the elements of section 10 of the Indian Contract Act 1872 must be fulfilled for an agreement to be considered a contract. All the agreements are contracts if they are made by free consent of parties, by a lawful consideration, by a lawful object, are not expressly declared to be void. That the contract between both the parties is void.
Now tells the court that there was no free consent.
Sorry?
No free consent was there. Lawful consideration was there, consent was there. Only there is a question of the majority of the minority. I think not more than that.
Okay, I would like to answer to your lordship with your permission. If a minor consents, we cannot say that it was a free consent because there are many ways to induce a person's, example, a minor can be induced with a consideration of chocolate. So that cannot be considered as a proper free will given consent. Because in this matter, the Mrs. Vadva and Vadva, the appellant, has induced the respondent with their drowsy dreams and doing that with a very low margin of cost, which is rupees 9 lakh, which is unacceptable for the market. And with this, they have induced the minor that we should be in a contract and so on.
Suppose a vice, who is a major, buys a chocolate from a house, from the shop, and the chocolate is delivered. Whether there is a contract or not?
I would like to request your lordship to repeat again.
एक जो एक मेजर है वो एक चॉकलेट की दुकान पर जाता है, चॉकलेट खरीदता है।
चॉकलेट दुकानदार ने उसे दे दी, क्या कॉन्ट्रैक्ट हो गया नहीं हो गया?
Yes, अच्छा।
अब एक महिला चाहे चॉकलेट खरीदने जाता है, उसने चॉकलेट डिलीवर कर दी, इसका मतलब बच्चा पैसा नहीं जाएगा उसका।
But that is not legally enforceable. That can be considered as a transaction, but that is not enforceable in the eyes of law, and that too cannot be bring in front of the court.
तो इसका मतलब ये हुआ कि बच्चे को बेचते हैं, सामान खरीदते हैं और पैसा ना दें।
It will not be considered as a contract because he is not competent to that.
Read section 68 of law of contract.
What's the contract?
I would like to plead the importance of this section. Shall I proceed?
So the respondent, Tarun Bajaj, is a minor at the time of contract. This can be seen easily in the facts of the case and hence highlighted in the government's hearing. Therefore, the consent cannot be deemed as a valid consent and the agreement was not to supply necessities to the minor, thus it is not a valid contract. According to Section 11 of Indian Contract Act 1872, every person is competent to contract who is of the age of majority according to the law to which he is subject. That Section 3 of the Indian Majority Act defines every person domiciled in Indigo shall attain the age of majority upon completing the age of 18 years and not before that. In the case of Kashipa versus Sripat, it was highlighted that a 17-year-old Hindu widow and her capacity to enter a contract shall be regulated by the Indian Contract Act 1872 as a domicile in British India. The contract made by her is regulated by law and domicile, and therefore she was not liable as a minor under the contract. The respondent during his minority is incompetent to enter a contract, and any contract entered by him will be void ab initio. In the case of Suraj Narayan versus Sukuai, the Honorable Court stated that a person borrowed some money during his minority and after attaining the age of majority, he made a fresh promise to pay the sum of interest therein. But the contract was not enforceable due to the reason that the consideration received during the minority is not a good consideration. In the case of Rajubala Dasi versus Nidhu Pandit and others, it was held that the Honorable Court a contract is specifically enforceable against a minor if he has reaped any benefit under the contract. Even though a minor cannot enter a contract, yet the guardian of a minor can validly enter into contract on his behalf. Now I would proceed further to the next point. Ratification on attaining majority is not permitted. That an agreement with the minor is completely void. A minor cannot ratify the agreement even on attaining majority because a void agreement cannot be ratified. A person who is not competent, an act can give it validity by ratifying. In the case of Suraj Narayan, as I mentioned, and similarly in the case of Kundan Devi versus Sri Narayan, it was held that if a person has received a part of benefit during the minority and a part of attaining majority, a promise by him to pay both if made after attaining majority is with a valid reason and enforceable. Therefore, respondent that is minor is not competent to give a valid consent. Hence, the contract between Tarun Bajaj and Ms. Vatwa is void and it does not fulfill the basic essentials of Section 10, Section 30 of Indian Contract Act 1872. I would like to call my co-counsel for the further issues.
With the permission of your
Lordship, shall I continue with my submission?
You are citing only the provisions of the various acts. But what is the view? What is your view regarding the understanding of the Tarun Bajaj that he was engaged in other profession like music, director, etc. But because that he was very much in the position to understand each and everything. But what is he going to do anything else related to the buying of a house or anything else?
Would you Lordship please repeat the question because of the dubious voice from my Lordship?
मेरा कहना ये है कि इन्होंने बार बार ये बात कही है कि वो अंडरस्टैंड कर सकता था सब चीज़ों को, उसका म्यूजिक डायरेक्टर के रूप में भी काम कर रहा था, वो दूसरी एक्टिविटीज में भी इन्वॉल्व था। तो इस बात में आपका क्या कहना है कि वो अंडरस्टैंडिंग नहीं कर सकता था? क्या उसकी अंडरस्टैंडिंग नहीं थी, या ओनली यू आर टेकिंग द बेनिफिट ऑफ द लॉ, नॉट ऑफ एनी अदर थिंग?
No, Your Lordship. Since because the minor contested in this very statute intakes all the ingredients, so we have not expectedly argued that. But with your permission, I would like to proceed with that. So the position of respondent in this case is that he is only a prodigy in one skill. He doesn't have any idea whatsoever about the construction field or the project that he was in contract with. And on that condition, it can be known that he has a very innocent knowledge of that. And on that basis, he should not be compelled to pay such a huge amount of money at the stage of his this poverty, because he has lost his money on the several times.
Actually, my view is that Mr. Tarun was not so innocent that he could not understand the things, what is going on.
He may be ignorant of the laws because of that he is not of nature, but he in that case in the whole contract he was very innocent about the malice intent of the appellant, Mrs. Wagner and Wagner, because he didn't know the amount of the project that would have costed him, or the quality. In the further submission we have submitted that the quality of the construction was very poor, and this was not intended, this was not expected from a minor to comprehend or to judge the quality of the, or inspect the quality of the construction at the earliest stage.
You yourself admitting that he was in position to understand that the quality was inferior.
At later stage, he was after paying an amount of rupees 3 lakhs through EMI. He then, when he was also manager, he then realized that the quality of the project or the work is inferior.
Anything else?
Please.
That the respondent has already paid the appellant rupees 3 lakh of the contract of the entire project through monthly installments EMI of 20,000 rupees per month till 15 consecutive months, and the respondent got to know about the substandard and dissatisfactory material used for the construction by the appellant in the respective 15 months. Hence, the respondent estimated that this would have cost the appellant rupees 3 lakh only, which was already paid to the appellant in the easy monthly installments, 20,000 rupees per month. I would like to call my co-counsel for the training.
With the permission of your Lordship, shall I present my claim? It is humbly prayed before the Honorable Court to declare that the contract between Wagner and Tarun Bajaj was void and void as an issue. Declare the judgment passed by the learned civil court is not to be reconsidered. This is the appeal filed by the appellant, that is Mrs. Wadhwa and Wadhwa. Award the cost of legal expenses of the present case in the favor of the respondent.
Okay, nice. Thank you. If you want to say anything else, within 2 minutes.
So firstly, I would like to tell the opposite counsel that the name of the defendant is Tarun Bajaj, not Shalini. Second, sir, I agree with the defendant that Tarun don't know about the contract, but he also did not know about the contracts he had made with the various producers, directors, or the music companies. Did he never contacted before this? And also, the opposite counsel has said that the town had paid the installments and he has paid ₹3 lakh. That if he had paid the ₹3 lakh, there is no fact that he had paid ₹3 lakh by the installments anyway. And if he had paid earlier, then why he is ready to give ₹9 lakh in the contract?
And Honorable Court, it is must be noted that the Indian Contract Act of 1872 is of a colonial era, and even today, at today's time, cities are modernizing, society is modernizing. So that how can you claim that you will be governed through the colonial era laws? Sir, my point is that at today's time, people are changing furniture, mobile phones, and everything. Whenever they feel need. Whenever they feel like this furniture or all these things are old, we will buy new ones. So how will you expect the societies to be governed through the old colonial law eras? And it is well said by our Prime Minister that there is a urgent need to change the colonial law eras for the better governance of India. Whether it is of a civil nature law or of a criminal nature law.
Thank you. Mr. Respondent, you want to say something?
With the permission of the judge, I shall ask the bench if the said verdict were to be taken as a reviewable round or should we take as their submissions. In that case, I would request to put very concisely that what are your questions. And I would like to take apology of this bench that I mentioned the wrong name of the respondent, which is not Tushar and it is.
How you define right? You are writing okay.
Yeah. They said.
Am I please pronouncing rightly?
For the same reason, I have taken opportunity and please.
Mr. You are presenting your case in the final round, not in the preliminary round.
5 minutes.
If you want to say.
Just because we were okay, last one. So, as my relevant counsel for the have already admitted that he is a well-known figure throughout India. Since there is now there is no need to define that they didn't know the age of the minor. Secondly, the ratification being talked about here is not correct because there is no new factors as established through various case laws. That there should be a new case law and a new consideration in another innovated contract. Hence, the second contract is also on the same ground that the contract was done with the minor and the contract is void at initially. Also, the opposite counsel have raised the query that the sum of 3 lakhs was not paid, which is
The last thing I want to say that both teams contesting them and put their views nicely in favor of his case. Law point of view, dissidents, in fact, you are also, both teams have raised their issues very well. So, I would like to congratulate to both of the team. It is hardly matter that who will win, but both have got, both representing well. Thank you.
Thank you, sir.